Principles of agency. This is a big one. This is 10 test questions. So, it's in my top 3 categories you've got to nail. And by the way, this is your job description and your duties that you owe to customers and clients, the general public, and the people that hire you to represent them. Now, this is very well going to come up on the national or the state exam. But the first thing I want you to know is your relationship to you as a salesperson. That's the type of license that you're getting here in Iowa, versus the relationship to your broker and the brokerage. Your broker is in charge of the contracts and the commission dollars. Any compensation you make, no matter what they call it, commission, flat fee, finder's fee, referral fee, dollar per hour, any money that you're bringing in exchange for your real estate duties goes to your broker. The contracts are your brokers. What's going to tie you to your clients is the agency agreement is going to say, for example, Amy Schaefer and Sarah Smith agreed to go into a representation agreement where Amy Schaefer Real Estate is going to serve as your representative as a seller. On behalf of Amy Schaefer Real Estate, as a broker, I appoint Amy Schaefer to specifically represent you. So that's what's going to connect you specifically as an appointed agent to the broker's contract. The other level of this is any monies that you bring in go to your broker. So here's the fantastic scenario. I hope this happens to all of you. You're walking out of closing and someone says, "Dang, Amy, you did an amazing job. Without you, we would have never found our dream home. And we would like to give you a $1,000 bonus." Can I, Amy Schaefer, accept that money? No, I cannot. If that money is going to change hands and a bonus is going to get paid, it's got to be in writing and it's got to go to the brokerage. So the check in my scenario is going to go to Amy Schaefer Real Estate, and then I'm going to get paid according to my independent contractor agreement. Now, with that independent contractor agreement, I think you need to know that that functions differently than an employment contract. As an independent contractor agreement, you get paid when you perform. You're not guaranteed a salary, you're not guaranteed benefits or tax withholding. So the question might come up, if I change from getting paid as an independent contractor, Amy Schaefer, to getting paid as a business entity, does your relationship with that independent contractor agreement change? The answer is no. Your broker doesn't now owe you tax withholding or Social Security or unemployment insurance, nothing. You're just going to get paid, Amy Schaefer. Now you're getting paid as a business entity, like an LLC, for example. The other big rock I think you need to know is a power of attorney, POA. A power of attorney is a legal written authorization for someone to act on your behalf. And we've discussed that there's several different levels of a power of attorney, whether it's financial, medical, or in this case, we're talking real estate. That means someone has written legal authority to sell property on your behalf. They don't need to wait for you to get back from vacay. They don't need to call an attorney. You are their legal written authorized person to act on their behalf. Another term for power of attorney is a universal agent. It's a universal agent. They can act on your behalf and sell any of your real estate, right? That they're authorized to do. That's a universal agent. The next thing that we need to dive into is knowing the difference between single and dual agency. A single agent in a transaction represents a buyer or a seller. So let's say you're selling 123 Banana Street. In that transaction, you're representing buyer or seller, one or the other. Dual agency happens when we represent buyer and seller both in the same transaction. So 123 Banana Street, you're representing buyer and seller in that deal. The key thing with dual agency is it must be disclosed to both parties, the buyer and the seller. It's got to be disclosed in order to do dual agency. Then the other area that I think you've got a lot of content for this section, at least 3 test questions, maybe more, but at least 3 are going to come from your fiduciary responsibilities. Now, what is a fiduciary responsibility? That right there could be a great question. A fiduciary relationship is something that we establish with our client that means we put their best interests above anyone else's. It's a special relationship. And in that situation, they might use the word principal. That you are representing a principal, and here are the duties you owe them as the person that you represent in the transaction. Now, there are 6 fiduciary responsibilities to cover, and my acronym for that is COLD AC. Care, obedience, loyalty, disclosure, accounting, and confidentiality. I like the acronym COLD AC because when I sell a property, I want the air conditioner to work. I would know the definition and an example of each of those 6. Here is the idea that just by having a real estate license, the public assumes you know more than the average Joe. And the answer to that will be yes, you do. But with it, here's an example of care. Should you go in and promise a client that you can get them a certain price? You shouldn't overpromise and underdeliver. Should you go into a seller appointment and tell them their house is worth $300,000 when you know it's only worth $250,000, but you tell them $300,000 so that they like you and they hire you? That's not being very careful. That's setting unrealistic expectations. The next level is obedience. And this means that we need to follow our client's lawful instruction. Lawful instruction. You can't break the law for them. Otherwise, what they ask you to do, you need to do it unless it's something that you didn't do in the first place. Then it's kind of a moot point. Here's an example. Let's say you put a sign in a seller's yard and you get them a bunch of showings. And the seller calls you one day and says, take the sign out of the yard. Now, obviously, there's benefits to having the sign in the yard because you've gotten them a lot of great showings. But there's also no law that says you've got to have a for sale sign in your yard in order to sell your home. So the point of a question like that is, you know that you should be obedient to them and remove the sign. What would be an example of something you shouldn't do is, let's say you've got a seller that says, Amy, do not show my property to any families because children are noisy and sticky and snotty, and they'll ruin this property that I worked so hard to build with my own bare hands. Can you follow that instruction? No, you cannot, because it would be a violation of family status under the federal fair housing laws. Right? Loyalty is the next one, and that means you put their interests above your own. And by the way, you got to do that. If you put your interest first, not only are you ruining your fiduciary duties, but people will smell your commission breath coming from a mile away. They will know that the only thing you care about is cashing checks and snapping necks. But the example of loyalty is, let's say I'm showing a property to a buyer and I walk in and I think, dang, this would be a great opportunity for my own investment portfolio. What do? I do nothing. You do not want to compete against your own clients. That same rule applies for you and immediate family. So whether the question is your investment portfolio, your mother-in-law's, or your husband's, the answer is the same. You do nothing and you let your buyers proceed. Now, the question I sometimes get here is, can I write an offer on the same property with multiple buyers? And in Iowa, the answer is yes. You can write an offer with as many buyers as you want on that property. You just cannot write it one for yourself. And of course, if you're writing offers for multiple buyers on the same property, you're not going to coach them to write an offer and disclose what the other buyers have written that would put them at a disadvantage. Number 4 is disclosure. And this really means that we've got the right or the obligation to be honest with everyone in the transaction. Now, we should not do it to the detriment of our client that would reveal confidentiality and put them at a disadvantage when negotiating. But if closing is going to be delayed, you need to be honest that closing is going to be delayed with all parties if something really does come up. Now, if you got to share that it's because your clients had a knockout, drag out appointment with their divorce attorney, no, that would be confidential and put them at disadvantage in the transaction, but you should let people know what's really going on. Next up is accounting, which means any real and personal property that we take in on behalf of our clients, we need to be accountable for it. Whether it's keys or earnest money deposits, we've got to be accountable for personal property, which could be physical or financial. The other layer of this is, when do you owe a duty to your buyers, sellers, tenants, and landlords to update them about the status of their transaction? And the best answer is upon request. There's no 5-day, 10-day, 30-day interval. It's if your clients call and say, Amy, what's going on? Did the appraisal get done this week or not? You got a duty to answer them. You can't say, oh, you'll learn about that appraisal on the 15th of the month when I do my 2-week update. No, you got a duty to answer them. And last but not least is confidentiality. My easiest way to describe this, or this is my Amy version, is you should not disclose anything about a client's strategy, motivation, or finances in a transaction. You should not disclose anything that puts them at a disadvantage when negotiating. So, for example, I write an offer on a property. Would it make sense for me to call that listing agent and say, hey, I wrote an offer on this, but we're really, really motivated to buy it, so make sure you give us a counteroffer? That implies we're willing to pay more, correct? Or I went through an open house one time, and the listing agent said, hey, if you got interested buyers, write an offer. My seller is really motivated. I know he'd take at least 10,000 less. That is appropriate if you have it in writing and you have it permission. Otherwise, you're giving away confidential information. Can I just tell you something quick for your career? It's never quick. But one thing I've learned, when sellers say, Amy, tell people that we're motivated, I pump the brakes and I say, what does motivated mean to you? Because I've learned oftentimes when a seller says they're motivated, it's by timetable, not by money. But if I go to a buyer and I say my seller's motivated, what do you think the buyer's going to assume that means? Money, money, money. They're not going to assume it means the seller will close in 2 weeks. They're going to assume it's financial. So when I've got a seller that says that, I clarify, what do you mean by that? And if it does mean that they're financially motivated, I use that as an opportunity to discuss the idea, if you're motivated to take $10,000 less, should we just sign an agreement and reduce the price and advertise it to the world that you mean business? Let's get a signature on that. And if that makes sense to them, then make it for realsies. Don't just talk about it. Have them sign a price reduction. The other one that might come up around this is, if someone is pre-approved to buy a house, that's not confidential information. Pre-approved and their maximum spending limit, that is confidential information. Let me give you something else for your career. If I've got a buyer that's pre-approved for $500,000, but we're only going to be purchasing at the $300,000 level, I do not hand over a pre-approval letter to the seller that says 500 on it. I have the lender write a letter that reflects the price point we are purchasing at. The only way I would present that $500,000 letter, if we're writing at the 300 price point, is if I'm up against 5 or more other offers and I want to make my buyer look so solid, so ding dong ding solid. Then that maybe would make sense to coach your buyers to have a letter like that. Otherwise, if they're approved higher, I don't want a seller to know that and then think they're, money bags. I'm going to have the lender write a letter that matches our price point. Does that make sense? Okay. Two of you said yes, I'll take it. Here is our next thing to tackle, and that is seller representation agreements. But I will be honest with you, really, this includes a lot of buyer representation agreements now as well. And this is the form that doesn't just say, yes, Amy Schaefer is representing you. It says how long, and what is going to be the compensation, and what specifically are my duties to you for either helping you find a property or helping you sell your property. So it's not just going to say, I've got these fiduciary responsibilities. That's going to be an agency agreement. Now we're going to fine tune, what work am I actually going to do for you? What work am I not going to do for you? And what's the compensation behind it? There are 4 types of basic listing agreements. There is exclusive right to sell, which means the seller hires one agent. They cannot do a for sale by owner, and the listing agent is going to get paid no matter where the source of the buyer comes from. So one agent gets hired, and no matter what the source of the buyer comes from, the listing agent's going to get paid. Exclusive agency means that there's one agent again, but the listing agent only gets paid if they are the ones that instigates bringing a buyer. Otherwise, the seller still reserves the right to sell it on their own and find their own buyer. Next up is an open listing. And this is when the seller, or it could be a buyer now, hires multiple agents, and the one that gets them under contract is the one that gets paid. And they still reserve the right to work on their own, example, as a for sale by owner, and not pay any commissions if they're the ones that find the buyer. Now, here's what I want you to know, and I'm going to have you add this. The question that could come up on the state or national, and you could get this multiple times, is if you know that a buyer or seller, if you got any reason, any inkling to know that a buyer or seller has an exclusive arrangement with an agent already, when can you approach them to do business, or when can you solicit them to do business? So we know or have reason to know that buyer or seller is already under contract with another agent. When can we approach them? And the answer is you can't until their agreement expires. The only exception to that rule is if that buyer or seller approaches you first. The key word you want to look here at is exclusive. Exclusive. If it's an open listing, you can approach them at any time because they hire, that whole point of that one is they can hire multiple agents. So the key word here is exclusive buyer or seller relationship. You cannot approach them unless they approach you first. And let me put this out here for your career, because this will happen to someone, unfortunately. You're going to get your real estate license and you're going to be so excited about your new adventure, and you're going to have the world by the tail. And one morning on your way to the office, you're going to be backing out of your driveway And in the rear view mirror is going to be a for sale sign in your neighbor's yard, and it doesn't have your name on it. What? Even Hazel woke up to that. And I will tell you right now, my bet is that listing is going to hang around for a long time and not have a sold sign on it. And you're going to be driving by that every day, taking your kiddos to school, thinking, why did they hire that agent and not me when I live across the street? And you're going to want to go over and knock on their door and say, I live right across the street. Why didn't you call me? I could have gotten this sold by now. Your marketing online stinks and your price is wrong. And I know all the things to do. You cannot do that unless they approach you first. It will happen to someone. I don't want that to happen to you, but it will possibly happen. And it's going to be right there. And you're going to think, I'm here. Why? I've got to go talk to you. Nope. You got to wait for it to expire, or you got to wait for them to approach you first. The next big thing is a net listing. This is the fourth type, but I want to pull this one out because it is illegal in most states, including Iowa. A net listing is where the seller comes to you and says, for example, I just want to net 100,000. And then you list their property and sell it and keep the difference between commission, between the sales price and the net. That is illegal in Iowa because we don't feel like it protects the public, because we're not disclosing to them what the list price is or what the commission rate is. They've got to know what the list price is. They've got to know what your commission fee is. So those are illegal in Iowa. And you might get asked a question that doesn't even use the term net listing. It might be something that says a listing scenario where the seller gets a net amount and the commission is paid to the agent between the sales price and that net amount. What is that typically considered? And the answer is illegal. So you might even see that, and they don't say the words net listing. It's illegal. You've got to be in a scenario where you're listing in the contract the list price and your fees. That's got to be in writing. The other big rock that I want you to know, and this is for buyer and seller, I'm going to combine these for you, is when do these agency and listing agreements end? Now, we're not talking about purchase agreements. We're not talking about leases, because a purchase agreement and a lease is between a buyer and a seller, a tenant, or a landlord. We are talking about an agreement that's between a brokerage and a client. Okay. And with that, your first opportunity to end an agency agreement is completion or performance. You did your job, you got the deal closed. That is our happy dance when we make money. Am I the only one that gets happy when she has money in her account? I didn't think so. But you did your job. You did what they hired you to do. Okay. That's your first opportunity. Some other things to keep in mind is these agency and brokerage agreements end death or incapacity of client or broker, not you as a salesperson, because that contract was not yours. You were just appointed on it. So it's death or incapacity of the broker or client. You die as a salesperson, no one cares. No, of course they care. But your broker is just going to appoint another agent in your office. Okay. The other big one is expiration. So your listing agreement or your agency agreement was January 1 to June 30th. July 1st, that's expired. Those clients can go hire someone else. And then the other opportunity is by mutual agreement between buyer and seller client and your broker. Mutual agreement is the other big one. And then there are a couple of clauses that might be in a buyer or seller agreement, such as an automatic extension clause. Now, these are illegal in Iowa, but an automatic extension clause would require the buyer or seller to give you notice in order for the agency contract to terminate. We don't allow that in Iowa. We have hard start, hard end date. You can always extend the hard end date, but we don't require clients to give us a notice. The other one would be a broker protection clause. That is a clause in the agreement that says if you transfer this property to anyone that I identified because of my marketing efforts, if you transfer this property to anyone after the expiration date within this time frame, you will still pay me. And the really great example that we came up with the other day is, let's say I've got your property listed and the expiration of our listing agreement is June 30th. And I bring you a buyer on June 28th and you sign the agreement. That's going to close after the 30th, correct? And that broker protection clause is set up as a time frame so that if that closes after the expiration, you still agree to pay me. That was a great example of that. Now, 10 test questions. I do think that you need to know your relationship between broker and salesperson, who controls the contracts and the money. I think you need to know that independent status of independent contractor agreement. I think you need to know a power of attorney. I absolutely think you need to know the difference between single and dual agency. Then under fiduciary responsibilities, that cold AC of care, obedience, loyalty, disclosure, accounting, and confidentiality, there I think you're going to have at least 3 test questions. Maybe as many as 5. That's a big chunk. Then the other area that I think you're going to have at least 3, if not more, is how these agency agreements work between the exclusive right to sell, exclusive agency, and open listing. I do think then you could have another 1 or 2 questions that you need to know the term net listing, automatic extension clause, or broker protection clause. That could be another definition 1. And then I think you'll have 1 or 2 questions about termination of these listing or agency agreements. Again, your first opportunity is completion or performance. The other big rocks are mutual agreement, broker and client, or death incapacity of broker or client. Do we like that? I like it too.